And we're back. Number 15. Hey, Chris.
Hey, Tim, good to see you.
Likewise, man. How's life?
Things are good. Lots of interesting things going on. Lots to talk about.
Yeah. So, what's a FOSITA?
Yeah, you love pronouncing the acronym. It's so there's this idea in patent law of a person of ordinary skill in the art, and it's a long name. So people either do the acronym or they'll just say a skilled artisan. But this there is no person, like there's no one person that you can point to. It's actually a fictitious legal creation of an average person in the field. And depending on the field, that might be, just a normal person, or it might be, a PhD, a postdoc, a Nobel Prize winner. It could be someone super educated and super skilled. It all depends on which field you're talking about.
I guess the question we're going to dig at today is like, could it be AI?
Maybe so. That's actually a great question for us to talk about.
Uh,
Of course, AI is not a person. So the P, the first part of your acronym, is person. And at least in the patent field, lately they're saying person is a human, like an actual human being like you and me.
that's
So
right.
AI, for patent purposes, can't be an inventor. At least that's the way, the US and the UK and other systems are interpreting inventorship laws. But
Okay.
it's an interesting field.
Yeah, and I think even just finding the right framing, and sorry to start off with the acronym that is FOSITA, PHOSITA. Oh gosh, that's a mouthful. Anyway, and that really sort of comes into play when you talk about whether or not a patent's obvious, right? If you try to get a patent invalidated based on obviousness
Well,
claim.
it actually comes into play a couple different times. So, why do you need to create this fictitious legal person? So one is obviousness, which we'll talk about a lot. The other is enablement. How much do you have to teach and guide someone in a patent application depends on who's reading it. So the more skilled and better an expert it is, the less guidance they need to make and use your claimed invention. So this person of ordinary skill in the art, skilled artisan, actually comes into play a couple different ways. And it's either a good thing or a bad thing, depending on if you want the patent to be valid or if you're trying to knock out the patent.
That's right. Okay, so uh, where this got started in the last 48 hours of our life is I put out this LinkedIn post, um, soliciting, all of our friends to sort of point us to anything written about this topic of the intersection of AI and patents, in particular when it comes to obviousness or non-obviousness, and the topic of trade secrets. And that is a sort of a different standard, but similar in a way, readily ascertainable. And so, anyway, we've got some really great, a few really great sort of follow ups on that thread. There's a piece that I'll just give a little shout out to Robert Plotkin. Really great piece that he wrote somewhat recently, early January 2025. He's a patent attorney, does a lot in software, and this piece that he published on IP Watchdog is really great. And it really sort of gets at the heart of the question I was asking, which is essentially, if you can envision a world, well, even today's world, but let's just like project out a little bit further, where these AI systems are incredibly capable at predicting things, at having the answer. And I think this example that we talk about, or he talks about in the article, is some chemistry, right? A new molecule for whatever, or a new design for a semiconductor. Can imagine now that this person having ordinary skills in the art has access to these AI systems, which can kind of give you an answer sort of straight away, right? So it's not like you had to toil for 5 or 10 years to figure out that answer. you just went over to your computer, typed in some inputs, and there's your answer, right? So there's your new molecule, and it should work for all these reasons. Go make it. I guess the somewhat, not cynical is not quite the right word, but I'll just say cynical view is, okay, if the entirety of human knowledge is going to be readily accessible, if new and interesting capabilities are going to be a few clicks away, or answers to problems are just a few clicks away, like where in the heck does that leave the patent system? And then we'll get into trade secrets in a bit, but I guess I'd postulate, like, isn't everything going to be obvious in a way, or meet that obviousness standard simply because skilled artisans are going to know, I use this model to do this, right? And there's the answer.
Yeah, and obviousness, it's one of those words that give patent lawyers headaches or conniptions because
I
it
could see it
doesn't
in your
quite
eyes.
it doesn't mean what it means to average normal people. So in the patent world, it's not obvious to try. Like everything's kind of obvious to try, but obvious means it's obvious that it will work, with some very high percent likelihood. And yeah, I always say AI is a tool. Like fundamentally, AI is another tool that happens to be incredibly powerful. But it makes that prediction of whether something will work or not much more predictable. So you're right. Like the ability to have someone say, or a patent office say, your invention that you're trying to patent is obvious becomes a much more compelling argument. And you as a patent seeker, patent applicant, you're going to have to jump over a higher bar than you used to because the tools are suddenly much more powerful. So it will change the landscape and make it more difficult for a patent applicant.
Yeah, and I've read Robert's IP Watchdog piece a couple of times now. It's really good. Um, it's optimistic for sure that the patent system will still be standing. It'll find a way to adapt to this new world order. But I think one of the super interesting things that's like probably happening in real time right now, and nobody's quite sort of put their finger on it, is that you have machines that are inventing. I mean, let's be serious. The machines are totally inventing. Okay. And then the human steps in, does some analysis, and that sort of collective becomes the invention. And that collective goes into the patent. Okay. So I'm being maybe a little crass, but that's kind of probably what happens in a lot of today's invention. Um, okay, uh, you can see a world like forming sort of very quickly where um, you're going to have people trying to invalidate patents left and right because they're going to say, well, the machine invented that. You didn't invent that, right? And so aren't we sort of staring down the barrel of this, like, well, you're going to have to sort of um, you're going to have to be in a position as the inventor to show where the invention was, but where the human step was.
Yeah, that's totally right. And it's kind of an extension of a normal way of invalidating a patent, which is to attack the inventorship. And
That's right. Yeah,
people have been
that's
doing
my
that
favorite.
for a long time where
Yeah.
there's either a person missing who should be on there,
Yep.
or what more often happens is a person's on there who should not be. Like you
Totally.
add the PI of the lab to every single patent, or you add a technician because they worked really hard, but they
Yeah.
didn't actually invent anything. But they spent 80 hours a week in the lab. So it's very normal thing to do early in a patent litigation is the defendant will scrutinize the list of inventors. And if there's anything wrong with that list, that's a grounds to invalidate the patent. And I agree with you. I think there's a 99% chance that people right now, today, are looking at the laws and saying, well, if AI by itself invents something, I can't patent that. So why not just add a human? Basically, skirt the problem or avoid the problem by just adding
Yep.
Tim or Chris or whoever,
Yeah.
even though arguably you didn't actually invent anything. And it will probably make it through the patent office because the patent
Right.
examiner won't
Yep.
have that information available and really has no mechanism to figure out, did Tim and Chris invent anything? They just kind of mostly take it on faith or just rely on the applicant to get it right. And it won't be until there's litigation that it comes out that you and I actually did nothing, but we were listed there. Therefore, the inventorship is wrong. Therefore, the patent's invalid. Therefore, the defendant wins. Uh, so it's not a whole new way of invalidating a patent, but it is a different wrinkle where, yeah, guaranteed people are adding a human inventor, well, inventor in quotes, today. Like, I'm sure
Yep.
it's happening already.
Yep. Yeah, no, my favorite version of that, by the way, is like, you'd see these, you'd see somebody's patent, right? A company, a competitor, and it'd be like, yeah, two really obvious inventors. Yeah, those people are clear subject matter experts and you know of them. And then you see this like third name, and you're like, this guy's like, it's like an investor, like he didn't invent anything. What is going on here? Those are always my favorite, when somebody that has like clearly no technical skill in that art gets listed. I,
Well, or the other option is, yeah, every single of the 1,000 patents in the company have the CEO
yeah,
on it, who's
exactly.
out
That's
out
actually
busy
better.
raising funds and schmoozing
Right.
investors.
That's right.
It's Yeah, it's just hard to believe, and
So
those also happen all the time.
this is like, I think really the first time. So look, you and I've been talking a lot about the convergence, not the right word. We've been talking a lot about the sort of the intersection of patents and trade secrets, right? Where's the patent, end and the trade secret begin? And so what it just struck me as I was starting to think through this stuff, that's like, wow, this is really the first time that I could really like clearly see that, wow, that we preach all day and every day, look, you got to write your trade secrets down, right? If you really want to be able to enforce them confidently, you got to know what they are, right? And lots of reasons to do that. This is almost like this is like, in a weird way, an extension of that, or the converse or something, where you're saying, look, in terms of the human step of whatever invention was, and if you're read Plotkin's piece, it's pretty good. It's sort of saying, yeah, like hey, I got all this data out of the machine. I went off and I thought about it. I saw this pattern. I saw that pattern. Good, good, good. I went and, whatever, told the machine to go do some more stuff, did some more analysis. There you go. That whole package. That's the innovation, right? Now, what part of that are you going to patent? Well, that's going to depend, right? But certainly that human step piece of it is critical. And it does feel a little bit like writing that down and making it clear that that was a human step is probably like super important right now. And it's not
It
clear
will be
anybody's
if
really doing that, you know?
Yeah, I mean, if you have any plans or risk of ending up in patent litigation, that needs to be well documented in advance of, what role did the human being actually play in inventing whatever it is you're claiming? And if that's vague and fuzzy, then the defendant, the non-patent holder or the patent infringer alleged, is going to say, that whole thing was AI and you just added a human to comply with the requirement. But you don't deserve your patent, it's invalid, you lose. So yeah, I
Feels,
think
yeah,
the better you document it, the better a chance you'll have of surviving at least that attack.
yeah.
And
It
it's really
feels
like
inevitable.
there's like three categories on the spectrum. So one is the old fashioned purely human, the inventor toiling away or taking a shower comes up with a brilliant idea. And then the other extreme is purely AI, which consistently courts are saying, AI cannot be an inventor by themselves. And then it's really this middle ground that very few people are talking about, which is why Robert's article is so refreshing, is, yep, humans using AI as a tool. And how can, what are the challenges and opportunities of that situation because AI is so powerful? So that's sort of the middle ground, which I think will be more and more important. And as usual, the better you document how things were developed and how you came up with ideas, the better off you'll be.
Yeah, and it also can't help but think that it's much like sort of now being able to see AI in writing. You're like, yeah, that's AI. Um, you know, I just wonder what that looks like as well from a patent examiner um, capability. Where they're able to actually have their own models that help them understand, was there really a human step in here? Um,
Yeah,
that's like
and the
super.
patent offices are thinking of ways and gradually deploying AI themselves to make them more effective, more efficient. So it's being used on both sides of the patent offices as well.
Yeah, and I think the again, back to my like slightly cynical side, would be, yeah, so we sort of are sitting here today thinking the invention. So let's just say, yeah, I saw this pattern, I went to a machine, came up with something, added my little human touch, fine. But gosh, it just feels to me like whatever that process I just said, right? I saw this molecule, I went through this process, out of, boom, like that. I just see a day in the not too distant future where that's just done already. You know what I'm saying? Like it's almost like the corpus of human knowledge is just going to go on some weird exponential, and then it's like kind of a prior art issue. It's just it's already out there. Like name your favorite like encyclopedia or Wikipedia or whatever. Whatever data source you want. It's just going to already be there. I don't know. Maybe I'm getting a little too.
Well, no, I think that that will happen. Yeah, if you invent a new drug or a new chemical compound for anything, when you write a patent application, you'll usually make some variations. Like you might have 5 or 10, similar but different molecules. But
Right.
using AI or using computers, you can generate 10,000 variants, and all of that can be disclosed or published or put in the public domain somehow. And now suddenly, instead of having 5 molecules as prior art, you have 10,000 or 100,000 molecules. So just the amount of information that's out there that's reachable through Google or search engines or Cass online is staggering. So all of these things make it just that much harder to get a patent that survives attack. And
Yeah.
we always talk about the patent system being like it's not broken or bad or useless. It's just less shiny than it used to be. Like the patent system used to be incredibly shiny. It was great for anything that ails you. But what's happening now is, some of that shine is coming off, and the patent system is still useful, but it's less useful and again less shiny than it used to be.
All right. So let's go into readily ascertainable for a few minutes, because I want to be fair. If we're going to pick on patents, we got to pick on trade secrets a little bit here too. So again, back to that example, is I go to the machine, I train it to do something, right? Um, I would not patent that, right? That training of how this machine, was trained, what it's doing, why it's doing it. That's all sort of, that's all trade secret sort of territory. The minute you go off into, human intervention, um, something that's not, super easy to reverse engineer, yeah, that's where you want to put your patent cap on, right? But much in the same way, if I say, hey, this is my trade secret, right? This machine training protocol, et cetera, right? Whatever it is. What do you think happens in that same world order where you've got this infinite amount of human knowledge or infinite amount of capability with computers, where you can just say, hey, go figure out how their algorithm works, right? Like, in other words, nobody can quite figure out the TikTok algorithm, but maybe give it a few more years and the machine will figure it out, right? And so that trade secret that was the TikTok algorithm maybe isn't really a trade secret anymore, because now the machine can predict it. Um, how do you react to that?
Well, and
I'm still
readily
free. I'm still.
ascertainable. Yeah, that's a long question with an equally long answer. There's really two parts to readily ascertainable. So one is just how easy or how difficult was it to ascertain. So like if you can hop on Google or using the AI tool of your choice quickly and easily figure it out, it's readily ascertainable. So that's kind of the ease factor. The other one is kind of a fairness or acting honorably factor. So like if you just sit down at your laptop and type something in Google, you haven't done anything that feels wrong. Like you haven't acted in a way that's not
Yep.
honorable.
Yep.
On the other hand, if you like pretend to be someone that you're not to get a login to a system that then you use to doing a scraping attack, or if you fly an airplane every day over a factory that's being built so you can take photographs from the air, which is actually one of the very early trade secret cases, it feels like you're acting in a bad manner. Like you're doing something that isn't somehow fair. And a lot of that goes back to how well protected was the trade secret also. Like if you had to go through sneaky kind of feels icky approaches
Yeah.
to ascertain the trade secret, the courts will say that wasn't readily ascertainable because you had to act in a bad manner to get it. Whereas, just doing a quick search or a quick AI query, anyone can do it without being dishonest. So there's kind of those two prongs of ease of figuring out. Like reverse engineering is fine in trade secrets, and people do it all the time because they buy the product at the store and then using a screwdriver and a hammer, take it apart and then figure out what's inside. That doesn't feel emotionally wrong. Whereas if I break into your factory at 3 in the morning, dressed like a ninja, and steal your laptop and then go home and decrypt it, that feels very wrong. Like
Yeah.
that's not
Yeah. It's
behavior you
breaking
want
the
to
law in and
encourage.
of itself,
Yeah, I
probably.
mean,
Yeah.
you're breaking lots of laws. Even with AI, it's like you might be breaking the terms of use or the label license that you clicked
Oh,
to
that's interesting.
agree without reading. And then if that doesn't grant you permission to reverse engineer anything. So that's acting in a way that is, somehow illegal, breaks contract, breaks the law. Those are behaviors we don't want to encourage.
Interesting. So let's say we're not. Let's say we're in a world where we don't have to, do it in an icky way. We can just go on our computer and ask the question and get the answer. Let's imagine that day is coming. Um, so talk a little bit about like the time of invention and how that impacts this. And so whether it's some sort of obviousness sort of argument or whether it's readily ascertainable, um, you know doesn't the standard apply on sort of the date of the invention or something like that?
Yes, in the patent world, everything keys off of your filing date.
Okay.
So when you actually electronically delivered your patent application to the patent office, it's that one magic date that everyone's crystal clear on. And you'd have to look at what prior art exists on that date, what is the level of skill of that skilled artisan as of that date. Like everything is keyed off of that one date. But
Same.
in your world where all this stuff is super easy, just type a few clicks on your keyboard and off you go, it makes getting a patent harder. But it also cuts both ways. Like what is readily ascertainable in a trade secret world has also gone way up. And that's why early in the conversation I said it's AI is the rising tide lifting all ships. And it makes it easier for everyone because you have this awesome new tool, but it also makes it harder for everyone because things like enablement and readily ascertainable have risen
Yeah.
as well.
So the idea that I convinced myself of, this is sometime in the last year, was that this readily ascertainable thing was gonna happen, right? So that's my belief, is that all of this, whether it's obviousness or readily ascertainable, all of it gets harder for sure. Um, and so the way in which you think about your trade secrets. So let's sort of put patents to rest for now. The way you think about your trade secrets in a in a low barrier, readily ascertainable, world order is a much more system level approach. So in other words, if I think about a discrete thing, discrete things are probably going to be relatively easy to predict. Okay. Whereas the combination of discrete things might be much sort of harder to predict. And
Yeah,
so,
I think that's right. You have to be more complicated or more of an integrated system approach to not be readily ascertainable. I think that's right.
like like system level thinking,
Mhm.
right? So it's almost like you have to kind of take yourself out of this mindset of like, that's the trade secret right there, right? And you have to sort of say, like, it's almost like it's biology, right? Like, one cell, congratulations, or one chemical process, congratulations. But do you know how this thing affects this thing like 7 steps downstream or upstream, right? And, again, without having the benefit of like lots of studying, lots of knowledge, that's going to be probably hard to predict, in systems, especially when one of the interesting things to think about there is you also have like the intersection of like business data and technical data, right? Of all different sorts, and sort of how they mash together to kind of say, this is the right strategy or this is the right answer. I think there's something really, really neat there.
Yeah, I think so. And you do want to still get the specifics right. And it's kind of like in patents where we do broad, medium, and narrow. Trade secrets are kind of the same way, where you want the discrete trade secrets
Yep.
documented, but then
Yep.
also the larger systems documented. So,
Yep.
all of your trade secrets, whether they're individual discrete ones or more integrated systems, they all are still interesting trade secrets and should be documented as part of your normal trade secret management program.
That's right.
But the the discrete ones might be more easily attacked as being readily ascertainable. But that's
Yeah.
not to say don't document them and don't count them as trade secrets, because they still are, and they might have tremendous value.
Yeah, and sorry I'm off on this tangent, and sorry if I seem to be talking out of both sides of my mouth. Totally agree. And there's cases every week that talk about particularity, and well, if you can't define the trade secret, good luck. So that's
Exactly.
very much in play today. That is the world we live in today. So don't take my system level thinking as anything other than I would start to think of trade secrets at both a discrete level and at a system level. Um, but yeah, certainly you've got to get the stuff documented at a discrete level, and based on today's court cases. So
Yeah, and I think adopting that broad, medium, narrow approach that we're used to using for patents into a trade secret mindset
yeah,
will help a lot. And just go from individual discrete trade secrets, and then go broader or go more integrated into a system level will serve
yeah,
you well.
yeah. It's actually something we've never really sort of talked about this, but much like in the patent world where you have composition of matter, you've got design, you've got process, methods, whatever. Um, yeah, that'd be neat to sort of like try to
Thinking here,
figure out also
trade
framework
secrets in
like
my
that,
mind,
and maybe it
there's kind
is
of
the same
a very
framework
clean two buckets,
for
or
trade
at least that's
secrets,
how
but
I think about trade secrets in
that's kind of
terms
it.
of
You just sort of spurred
technology
that
trade
thought.
secrets, where there's this whole intersection with patents.
That's super thoughtful and bears out in the litigation, frankly, right? As you see more business sort of data kind of litigation these days. So, and probably, sure. Yeah, exactly. Another customer list case. Yeah. So, one last quick thought. I think going into this discussion, I was really, and you and I are doing some writing in the background on this topic, but this idea that AI is eating your IP. I think today's discussion has convinced me that that's probably true. Um, and it's not completely clear if it's eating your IP, slowly for now, but it's going to accelerate very fast, or if it's just a bit of a you know uh, if it's sort of slow and steady, but as you say, this sort of also may increase the amount of IP, right? And so anyway, we may need to need to think about that. AI is eating your IP. Okay. Yeah. Well said. I think we end on that note. And yeah, thanks, Chris. Great stuff. See you next time. See ya.